This is Spa 102 Digital Monday. Today, Monday, on Hard Talk, our host, Karen Nunez Tesheira, and she has a very special guest. I'll allow her to introduce her guest. The topic, Caribbean Court of Justice versus the Privy Council. Good afternoon, Karen, and how are you? Karen, are you hearing me? Seems like we have some internet fluctuations here. Karen, are you hearing me?
Is anyone hearing us?
Yes, I'm hearing you. Seems like you're not hearing me.
Courtney, you hearing me?
Yes, I'm hearing you.
I'm not hearing you. But I'm not
I'm
hearing you.
hearing you.
We are hearing you.
I want to hear you too. I don't know what's going on. Usually, David McIntyre is here playing a tune, introducing the show,
I did.
and I'm not quite
It
sure
just
what's going on. So maybe I should use my
it just
phone and
did.
find out what's going on. Especially, I know time is your currency. It's everybody's currency, but I know it's especially your currency.
We are
So
hearing
I
you very
want to
clear.
respect that. I don't know what is going on at Power Studios. This has never happened before, actually.
I'm hearing you loud and clear,
I'm
and
looking for my phone.
Mr. McNish is hearing you loud too.
Ah, dear me. Usually have it right next to me, just in case. Yes, look at it right here. So I'm going to ring and find out what's going on. Thank you for coming and thank you for being on time. I like that. You know, we Trinis got a bad reputation for not being time conscious. Clearly, that's not true about Courtney McNish.
No, it is not.
Courtney, I'm trying to get him right now. I don't know what is going on. I do.
Your call has been forwarded to B-Mobile voice.
Well, I don't know.
You still not hearing us? Okay.
Let's see.
Hold on a while, Chief. Let's see what's happening here.
Nobody has called me and said anything, so let me see what's happening. David, we are there. I have Mr. Courtney McNish here. I'm here, and nothing going on.
Both of us are hearing you.
Yeah, but we're not hearing you. We're not hearing anything. He's not hearing. He's hearing
No.
me, but I'm not hearing him.
Yeah. I am hearing both you and David.
But you haven't usually he introduces his show. I'm not hearing any introduction, nothing like that. It's just
Listen, he's hearing both of us. I don't know how you're not hearing. And I'm seeing your mic is unmuted and everything, so I don't know.
but we're not see. Are you hearing David McIntyre?
Yes, I am.
Courtney, are you hearing David? Yes, he says he's saying you. So what would be the problem then? Should I start over again and try to come back on?
Let me call you on the phone.
Well, call me on the phone then.
Okay, I'll hang up your phone.
All right. These things happen, Dave. Courtney. We've had it happen once already. So what they're going to do is I'm going to hear what you have to say because David is going to call me on my phone and I will hear what you are saying. I know you are hearing what I'm saying and he apparently is hearing what I am saying.
That's correct.
So, right. So whilst we wait on him connecting me up, I'm waiting on him to connect me. My Lord, this is just things that do I need these stresses? No, I don't. Okay, whilst I'm waiting for him to connect us up. Okay, so I've answered you. So now you're hearing me. Everybody, so now I'm hearing. Courtney, you just want to say something?
Yes, I was always hearing you, Karen.
He's still not hearing me. I'm still
I
not
am hearing
Courtney.
you. Yes, I am
Courtney
hearing
me, but I can't hear him. Something is not right.
Hold on, Karen. Hold on.
Okay. Maybe let Courtney speak.
You have to turn down the volume on your system.
I'll have to turn it down.
Yes, the volume on your computers, and just
On
use
my
the phone.
computer.
Yes, turn on the volume or mute it, and talk to us on the phone.
Oh God. You always ask me to do things I don't even know what to do, eh? Oh God. Wait just a minute. Okay, I'm gonna mute it down. I muted it down.
Okay.
I muted it down.
Yes, but I'm getting a lot of feedback.
I'm still muted it down.
Okay, move your phone away. Use your phone by your ear or something.
I'm still hearing the noise.
Okay, it's gone a little bit.
I don't know what's going on. And I can't hear Courtney.
Well, you'll hear me on the telephone.
Are you hearing me
Courtney,
now?
can I hear you?
You're hearing me now,
Courtney?
Karen?
Yes, though I can't get back on. I don't know how to get back on.
We are seeing you and we are hearing you.
We are seeing you.
That's
And
okay.
we are hearing you
Well,
also.
that's good that somebody says see me and hear me. All right, well, let me get to the point. Yes, I'm back on. What has happened is that first of all, you notice that we do not have with us Denise Denham.
Denise Denham, I want to thank you very much for all the service you gave, very impromptu at the very last minute, to help me out because it's, let's just say it has its challenges that I do enjoy, but I do have challenges. And you have moved on to have your own show, and I want to congratulate you and thank you for all the assistance you gave me. But I know Courtney is and so I want to make that point. I want to mention after Courtney McNish has left us, I would like to mention a little bit about the Venezuela because it has implications for us to the energy sector. Definitely, with this whole, as Trump would say, confuffle about whether Maduro did or did not win. But let's go straight to Courtney McNish, who is a household name. And he has I can't spend too much time on his CV because there are two things. The reason I was able to, I have to be honest, twist his arm a little bit, but I knew him many years. I hope that helps. But he's a real professional, and he is one of the descendants of Americans. And he was surprised, so I don't know why, but he was surprised that I knew so much about the Americans. But I guess it's because so much of Trinidad and Tobago does not know that. So he's a very busy man. He is a chairman, and he is right now the American Heritage Commission. He's leading it as a chairman, and he has set up what they call a McNish Trust. So what I asked him and that's all based in Moruga. But what he's going to do for us first, and then he's going to spend 15 minutes with us speaking about America, which I think is important if we're talking about creating a cultural base as Mauritius has done. He is very knowledgeable. In fact, it was just coincidental. I should just say that when I spoke to him and twisted his arm a little bit, not literally, that he said to me he was in the process of writing one of his several books. He's written 9 books, publications, articles. He is the CEO of his own firm, Principal Consulting of Human Resources, and I've come up against him, and he is a worthy opponent in industrial court, no less. He was a member of the Police Service Commission, and so he's a very well-rounded individual. I didn't even know that you were in the Football Federation, but then I shouldn't be surprised of nothing, Mr. McNish. So what we're going to ask him to do, and he has promised to do, spend the first half hour, I think because he said, in fact, his first chapter was dealing with that. Many people, the topic is should we go the way of the CCJ, Criminal Court of Justice, or should we stay with the Privy Council? And he said to me that, by coincidence, Karen, I had just completed my first chapter of my 10th book, I suppose, and that was actually the topic. So what I'm asking him to do is, as I've read in many articles, one of the major concerns that people have is that because we are a small community, numbers, etc., that there's a fear of political interference. It's actually been written about by the former head of the CCJ, I think Justice Byron, and several other persons, the question of political interference with the not only selection of the judges, but in fact their judgment. So I have asked Courtney McNish, who is well acquainted with that, to address specifically that issue and give people, I hope, a sense of comfort. And off to you, Courtney McNish, Mr. McNish, and then he will pivot, as the other fancy word is, to talk a little bit about the Americans, which I think is for everybody's interest, and then we're back to CCJ again. So, Mr. McNish.
Thank you very much, Karen. And just for your audience sake, I do admit I've known you for many years. Many years in a different place, in a different incarnation. You didn't have to twist my arm as much as you are making it out to be. I certainly thought that the request was opportune, and it is something that has been troubling me as a citizen, as a professional, as somebody engaged in the law in terms of the academics, and as an integrationist. It has been troubling me. But one of the arguments frequently used against the replacement of the Privy Council by the CCJ is that the judges of a regional court, which the CCJ is, are likely to be subject to political influence and local pressures of one sort or the other. This is as opposed to the judges who sit at the Privy Council in England. By virtue of their mere remoteness, it is felt that they're insulated from such influences. That may be so, but there continues to be a downside. The downside, by continuing to stick to the Privy Council, we continue to give up our part of our sovereignty, to be the masters of our own home, to be able to use our local knowledge, our customs, our culture, to influence the judgments that would come from our final appellate court. But one has to therefore look at what the intention of the revised Treaty of Chaguaramas was. And the court was set up to be a dispute resolution institution to resolve disputes between member states in the CSME or CARICOM with respect to the requirements and alleged breaches of the provisions of the treaty. That is commonly referred to as its original jurisdiction. But then there's the appellate jurisdiction, where it is intended that the members of CARICOM, members of CARICOM, will in fact use the CCJ as a final court of appeal with respect to civil and criminal matters. That has not happened. Of the 15 fully contracted states in CARICOM, only five has, to this date, since 2001, only 5 has accepted. The court was inaugurated in 2005. So it's almost 20 years now. And only 5 states have accepted the court as a final court of appeal for civil and criminal matters. But interestingly, if you look at Article 211 of the revised treaty, nowhere there you will see anything providing for the appointment, tenure, removal, terms and conditions for the appointment. There's nothing in the treaty that provides those directions with respect to the judges. Instead, a fully independent commission, which is the Regional Judicial and Legal Services Commission, is the body charged with responsibility of selecting judges to sit on the court. Independent body. And to look and understand how independent this is, it's important for us to look at the composition of the members of that commission.
Mm-hmm.
The president of the court is the chairman of the commission.
Mm-hmm.
2 persons appointed jointly by the Organization of Commonwealth Caribbean Bar Association and the Organization of Eastern Caribbean States Bar Association. So the bar associations within the region have 2 members. 1 chairman of Judicial and Legal Services Commission of any contracting party, 1 chairman of the Public Service Commission of a contracting party. 2 persons from civil society, jointly nominated by the Secretary General of the Community of CARICOM and the Director General of the OECS. 2 distinguished jurists appointed by the Dean of the Faculty of Law of the University of West Indies and the Deans of the Faculty of Law of any of the contracting parties, and the Chairman of the Council of Legal Education. And then 2 persons nominated jointly by the bar associations of the contracting party. What struck me as I was doing this research is this: there are no political appointments here. These are members of bar associations, Council of Legal Education, the Faculty of Law from the University of West Indies, the Secretary General of the CARICOM community, Chairman of the Judicial and Legal Service Commissioner. These are all persons involved in the legal affairs throughout the region come together to form this independent commission for the appointment of judges. And
let's talk about the judges themselves, because one of the things I just want to mention, there's also an act, and in the act it specifically says that no appointment of any judge shall be made by any political or any other place. Specifically, while the commission itself, that treaty may be silent, the act itself clearly says that no appointment to a judge, the judgeship, can come from any political organization, party, or otherwise. It's very clear about that.
Very clear. The appointment of the president of the court, Karen, is slightly different.
Right.
The president of the court, however, is really appointed by the heads of government upon a firm recommendation from this commission.
Exactly.
So the heads of government simply act as a rubber stamp for the president of the court as recommended by the commission. If the heads of government do not agree with the appointment, they cannot appoint someone that they like or they prefer. It has to go back to the commission, and the commission will then select another name to make the recommendation.
Exactly.
Keeping it totally independent.
They're not going to rubber stamp. They are just a mechanism by which a formal mechanism for those appointments for which they have no say. And I also said you could probably want to mention the trust fund, which
yes, I will get to that.
Yeah.
Because there are two main pillars on which the independence of the judges stand. Yeah. It is the method of appointment and their funding. Funding. But with respect to their appointments, this independent commission treats with selection, hiring, discipline, fixing terms and conditions, staffing. Everything is done by this commission. Further, there's no provision in the treaty that allows for the extension of the appointment of judges. At 72 years, you must go.
Right. Unless you have a matter that still needs to, unless there's a matter that you have.
Yes.
Have started.
If there's a matter that you started, of course you complete it.
Our former chief magistrate should maybe be reminded of that, but I won't go into that.
So one cannot look for favors from a politician to extend my appointment and no. That and I think the framers of the treaty understood that it was necessary to put some ironclad provisions somewhere for the appointment of judges to secure their independence. Now, another way that judges, it could be argued that judges may not necessarily be fair or may be biased, is because the government controls the purse strings. This does not occur. As a matter of fact, the establishment of the Caribbean Court of Justice Trust Fund was such a brilliant concept that it has been advocated to be a funding mechanism in a multitude of other environments.
And how much money are we looking at?
Well, when the fund was first started, it came up to the initial capital investment, which was really put together by the Caribbean Development Bank, $100 million US.
Yeah, I could not believe it.
100 million US dollars. Now, how this was funded, that money was treated as a loan to the various 10, 12 members of CARICOM, and each one had to pay it back over 10 years.
Right.
So it wasn't burdensome.
Right.
And it was based on what you could afford by your GDP. For example, Antigua, Barbados had 135,000 US to put in. Trinidad and Tobago, however, had 31 million US to put in because of our size, and Trinidad and Tobago contributed the most. But by now, 10 years have more than passed, all the countries would have repaid the bank, the Caribbean Development Bank.
Right.
And the fund is now, could be considered on the way to being quite mature, and it has been working. The interest derived from the investment activities of the fund has been paying salaries, not only to the judges, but also to the members of staff, taking care of their terms and conditions. And from my information, we're having more funds available every year. You know, it's a trust fund, so you know rates of returns could go up, could go down, could flutter. But on a general level, the rate of interest returns to that fund has been positive throughout the period and has been more than sufficient to maintain all of the terms and conditions of the judges. Now, this is run by a board of trustees, by no politician. The trustees consist of the Secretary General of CARICOM, the Vice Chancellor of the University of West Indies, the President of the Insurance Association of the Caribbean, the Chairman of the Association of Indigenous Banks, the President of the Caribbean Institute of Chartered Accountants. No politician is listed in there. And these are independent professionals that are trustees of the fund, and they relate to positions of the fund manager who are investment experts. And these funds are invested worldwide. Worldwide. I suppose they must even have some Bitcoin, who knows?
Like the HSF has done quite well because most of their investments are in the US, and we have been, with all the ups and downs, I think they have done fairly well. So it goes to show that protection, I mean, you couldn't put it better, Courtney McNish. I mean, between the money, which is one of the ways you control, between the selection of the commission itself, and also the judges themselves. I don't think anyone could be a judge unless they've had at least 15 years distinguished. There are a lot of markers. You could speak to that?
Yes, the court was inaugurated in 2005. So it's 19 years the court has been in operation. I think it's a sad reflection on our region that two of the founders of the court of CARICOM, Trinidad and Jamaica, cannot find themselves the political will to become associated with the appellate jurisdiction of the court. We still going to the Privy Council. Jamaica is still going to to the Privy Council. And from where I sit, from my research, Karen, I see very little windows in the horizon where that will change probably in our lifetime.
You think so?
I have this great feeling I would not, because there is this fixation that the Englishman with the wig and the gong sitting in London knows better than we do. And he is fairer to us than we can be to ourselves. I find that most depressing. Most depressing.
You know what I started doing, but I just sort of began it, and then, because I didn't even know it was available. You know, data drives everything. And our court, I don't know, I can't talk about all the other courts, but certainly trying to be able, judiciary on their website. You can go, I don't know how I found it, because I certainly came upon it, what you call serendipity. I didn't know I would have found it, but I did find it. And what it does, it goes back to cases into the 1990s, right up to the present date. And you can see these are all appeals to the Privy Council. So, you know, if there is that concern that when you appeal from the Court of Appeal, the Privy Council overturns your decision, I think one good exercise which I had started, and then it was just too much in the limited time I had, perhaps a good exercise is for someone to go through, because it's there. And in fact, in the earlier cases, they just would tell you the name of the case, but they wouldn't tell you what it was about.
Yes.
But in later cases, they started telling you what the case, so you knew what you were going to look at. So you could put it into two categories. Those cases in which the state, either as an AG or as the, if it's a criminal matter, the state or AG if it's civil, or even an agent of the state at the DPP in a recent case, etc. Put that into one category, and then put the other case in another category, and just see to what extent, two things. To what extent those cases are overturned, the Court of Appeal decisions are overturned by the Privy Council. And then secondly, another thing which might be helpful, what are the comments of the Privy Council? So you can get a good sense. Listen, you're saying that you don't have confidence, but from when I was doing it, it looked as though most of the cases were being upheld by the Privy Council. And that's just speaking just anecdotally. I didn't do a scientific thing, but I think somebody needs to, instead of just talking about it, actually scientifically, and you have the information. It happens to every country. Yeah? I just look for Trinidad.
Yes. Look at, of course, you look at Trinidad. Yeah. So if I understand the point you're making, why do you fear going to the CCJ, but sticking with the Privy Council, yet the larger percentage of cases that go to the Privy Council are not overturned? This is the point you're making.
I want the numbers. Yeah, but I don't want to just make a statement like that unless I get the numbers. And it's available. That's the thing, because the website, if you go and you're doing all this research, if you go to the website, you will find it for every country. So you will actually be able to actually say, I'm not just saying this. This is the evidence. This is the evidence that our decisions of our Court of Appeal are not being overturned by the Privy Council. So this idea that we are not good enough, we're not capable enough, we're not competent enough, or we don't have enough independence, it's either going to be proven or disproven. I had not reached that point as yet.
But you know, that was one of some of the arguments that those against the CCJ has also put up too. Some persons have argued that the quality of our judges may be in question. But you've just given me the data that puts to rest and define the folly of that argument. Our judges must be of a significant quality and standard if the vast majority of their decisions are being upheld. So that
but you have to go and check it out. You have to check it, because there were a lot of cases. Like my case went to the Privy Council.
Yes.
So I'll be honest with you, Courtney. In my case, I was glad to go to the Privy Council. Now that's being on a personal level. The reason being, everything is unique because I am a lawyer. I taught at the law school many people, many judges, many lawyers. They're either my associates or my former students. So it put me in a peculiar position, and then I was in politics. So the other side, and the court which they had to drop it, was apparent bias. So you see, they had to drop it. But the point was, when I had the Privy Council decision, which every argument, they had 7 arguments, and every argument was struck down, I said to myself, so what you going to say now? What you going to say now? She had a friend on the court because she was a lawyer. She got because she taught somebody, because she's friends with somebody. They could not, I don't know anybody. So for me, on a personal level, I would not advocate it otherwise, but I'm saying on a personal level, it gave me a sense of satisfaction that I shut them up because they could not say that judgment was not, in my opinion, I had anything to do with the decision because it was far away in England. And by the way, too, okay, I won't go into that, but that was for me on a personal. That's a personal story because I'm in I find myself in a unique position.
Okay, I understand that. Oh, I'm looking at the time, Karen. It's almost it's going on to 5 o'clock now.
Yeah, but that was about Americans because I brought you here to say something about Americans. So before you go, let people know a little bit about it because many people do not know their own history.
Well, thank
you are a descendant of Americans.
I'm a sixth generation. I'm a 6th generation direct descendant. McNish is one of the original descendant names, like the Coopers, the Atwaters, the Burtons. There are a series of names that are still popular today, particularly coming from the company villages that are all original Americans. We came here, as you know. Sorry?
Could you explain what the Americans means and why? You know, because people have 7 companies, 6 companies, New Grant, and Marie.
Right. Well, we came here, we landed here basically in 1816, having broken free from the shackles of slavery along the eastern seaboard of America during the War of 1812 between England and America. America was already independent, but Britain had launched a counteroffensive against America to try to take back some of what it has lost. They encouraged the slaves on the plantations on Georgia and on the Camden River and stuff to run away, and they were accepted on the Navy ships of the British. As a matter of fact, our ancestors have become very famous because there's a group of Americans and freed slaves, then referred to as the Colonial Marines, that sacked Washington, D.C., burned the White House down to the ground.
That's what I heard.
And got away free with it. Maybe it was the color of their skins they were to hide in the night of the night. Before the war was concluded, a deal was made where the British recognized what you're going to do with these people. They train, they are military, they are armed. We can't send them back to the plantation. We can't put them back where they came from. So arrangements were made to have them not the word colonize, have them migrate, as it were, to various parts of the world. Trinidad, Bermuda, Nova Scotia, in Canada. Fine. My ancestors and many of those of other people still living and who are direct descendants came to Trinidad.
Where did they put you all there? Where did they put you all? Say why they put you all there.
Right. Shakon didn't want us anywhere near the enslaved people. Because we are talking about 1816, emancipation was 1833, some 16 years or 17 years after we came here free.
Exactly.
So we were placed in this very remote area down in the county of Savannah Grande, which is now Princestown, Moruga, New Grant. And we developed the area of Moruga because it started with the 6 company villages. All the soldiers, their families who came, they formed various villages. They had a sergeant who was in charge of every village, and they were given lands. Each family was given 16 acres of land on which to subsist on. Many of us still own our lands today. Many of us don't have the documents saying we own the land because there was a fire in the Red House of 1901, I believe it was, when a lot of the documents were destroyed. But by pure heritage, my family still has its land in six company. And many of us
sorry to cut you, but Papaniz is one of the most famous persons in Moruga that was an American that
Yes.
Vietnam Paul. We wrote about that lawyers, doctors by the carloads used to come to see Papaniza for some advice.
There's still a shrine to him. That's part of the tour of the American community. There's still a road, a trace it is called, where you can go and see his shrine. Papaniza did not appreciate being called an Obia man.
No, okay.
He didn't appreciate it at all.
Okay.
He was a healer. He was a spiritual healer. He was an advisor. He was a man of God.
Right.
But he was very gifted. And his gifts and his talents became known throughout the land. Lawyers, politicians of all race, creeds, businessmen would come to see Papaniza. And that is how he lived. That is how he was a practicing Orisha, but he hated to be called an Obia man. As a matter of fact, I had a conversation with his granddaughter. We had our sports and family day two Saturdays ago, and I had a conversation with his granddaughter. And she has some artifacts from way back in his time. They're absolutely amazing. They're absolutely amazing. Papaniza may be famous for that, but there are still many Americans who have made their mark both nationally and internationally. She's really my father's cousin, but I had she's much older than us. She's my aunt. Courtney McNish is one of the most decorated artists and fabric designers in the world. I mean, she died in 2020. But there are many Americans. The Tobis, Dr. Topi, Leslie Topi, David Topi, they are all of American descent, direct descendants.
And can I say Mrs. Manning's father, who wrote a book on it too?
Mr. Huggins. Yes. Mr. Huggins has written one of the famous books of Americans. As a matter of fact, we began discussions with the Ministry of Education last year. The Prime Minister, who attended our function in Sapa also last year, and they have committed to take all the necessary steps to ensure the introduction of the American history as part of the social studies curriculum in both the secondary and primary schools. If it was not for my father, I went to school and I never knew one thing about such a rich history of fighting soldiers coming to Trinidad, settling, developing an area and making a mark in this community. It's just not taught. It is just not taught.
I myself didn't know until I met Mrs. Manning, and then I found out. I said, "What is this American?" And then I found out the history. I mean, it made me so proud. This is the thing that we do not do. We do not educate our children about their history. Americans is such an important something for us to be so proud of. And you are right. If I could just say, of course, Papaniza is right to take objection to be called Obeman, because it is to deride him, it is to diminish him, and to put him into a kind of a box of, that taken away his intellectual capacity. And we know many of your descendants, including you, Courtney McNish, who you have an LLB and an LLM among your many, 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 many other accomplishments, as is true of the American bloodline. Clearly, a person not only who fought a battle at a time when slavery was alive and well in Trinidad and Tobago, as well as and so much so in America until 1868. And you all have much to be proud of. And we as Trinidadians do not appreciate what we have. And I hope that your efforts do not go in vain, and that I had someone else just finding the Dr. Rhoda Reddock on last week. We were supposed to be talking about something, but the point was, what she did talk a lot about is so much of our history is not taught to our children. So if you want to have any more party, because I know I took you away from your really busy thing, and I'm very, very, very honored that you spend this time with us, and I hope that people are listening and learning from this discussion.
Well, let me just say finally, for the first time, the American community will be coming out en masse for the Emancipation Day March from Independence Square to the Savannah on Emancipation Day the 1st. We never consider ourselves emancipated. We came here free. But we are part of the community of Trinidad and Tobago, and emancipation is indeed a celebration of freedom and freeness, and we thought it necessary that we be part of that. So for the first time, we'll be taking part as an entire community.
Can I come? I know I'm not a free slave. Can I I am so proud of of that part of our history, as I am of many other parts of our history. Not just there's so much that we do not allow our children, the way the Americans give their children a sense of pride in who they are. We need to take pride in who we are as a people, and the richness and the tapestry of our country, and and having you on this afternoon, Courtney. I have whole set of comments. I can't read. I don't know put on the wrong glasses. I have to tell you the truth. Yes, I know David reading them. But I'm sure it's a lot of comments, and we're gonna have you on another time as closer to the event. And I am very happy that you took the time off, and I see it. And you're right. I know you a long time, and it's always good to have you and to have you on the show. Thank you so very much.
Thank you very much, Karen. Have a good day, a wonderful evening.
You too.
Bye-bye.
Thank you. Take care. Bye-bye.
Thank you, sir. And thank you so much for the information. That was wonderful.
Did you learn a lot, David?
Yes, I didn't know about them. I always wondered why they named those communities Fifth Company, Sixth Company, Yeah, I used to be down on those side a lot back in the days when I was a DJ, and they say, well, okay, we have to go and play in Fifth Company or Sixth Company or New Grant.
Yeah.
When I went to New Grant, in talking with people, I always try to make friends with people who I meet when I go in these different areas to play as a DJ. I'll take time out to talk with them and things. And they were telling me about the Fifth Company and Sixth Company, and I was asking them. And I remember an old man was saying, those soldiers from the war, if they're from the Sixth Company, they occupy this area and they call it the Sixth Company. And if they're from the Fifth Company, they organize themselves in the area that they call the Fifth Company. So it was confusing until now.
Right. And that's why I'm glad that I knew that the McNishes and the Topis, and I knew that Mrs. Manning's father was American. I knew that. And I knew the history, but lately on. And what he didn't say, because she did one of her wrote a book. I think the American Embassy also co-sponsored a sort of a small, what would I call it, a videograph of the work. And she and Mrs. Manning made the presentation. What he didn't also say about why they got new grants is because when the war was over and of course the British lost, they wanted to kind of backpedal on their promise, because they did promise um, the slaves who had run away and who had joined them in their last attempt to return United States to one of its colonies. They did promise them that at the end of the war, that they would give them land and they would secure the freedom and give them land. And what happened was, a lot of them, they did go to, in Canada, Newfoundland. That's why they call it Newfoundland. They went to live there. Then in Africa, some of them went to a place you have Freetown. Freetown is the capital of one of those main West African states. It escapes me now. But what they also did, which may not be so, kosher to say, but some of them decided to go there and they sent them with English women to keep them company. Let's put it that way. And also, but what happened, what they did initially, they sent them to Bermuda to be longshoremen, and they said, no, that is not the promise you made. You promised us land. You promised us our freedom, and that's why you have new grants. Because that was when the governor then kept his promise and made the grant of the land. You remember he's talking about the acres of land? Made the grant of the land to those soldiers at fought who did not go to Newfoundland, who did not go Freetown, but who wanted to and went to Trinidad. And Trinidad was kind of safe because remember, it was nearly the end of slavery. And Trinidad was about one of the last countries that had been, you could really say, really had slavery, because it was the end of almost at the end of Venezuela. We're nearly at the end of the slavery. So that slavery was still alive. So they said, okay, but we let you go Moruga on the eastern coast and keep you sort of enclosed, so to speak, so that you don't infect, and that's what I would use, those who are still under slavery and give them any ideas. But that is where the word new grant came from, and the companies came from the soldiers who headed up the companies, as they call them, during the war. So, and that is so much of our history that we do not know.
Yeah, it's true.
So, so that was about the conversation today. But I think
we had a lot of comments coming in. Elizabeth Bain, she was happy to see Mr. McNish. Benwari Kakika, if I pronounce it right. The Americans are still descendants of slaves. Benwari, right? Joycelyn Dial Singh, Papa Niza, thanks for the information on Americans. I believe Hazel Manning is a direct descendant. Yes. And Miss Dial Singh is also asking for the first name. I guess it's the first name of Mrs. Manning's father, What Huggins. Right. Yeah. So those are most of the text messages that right. Banwari always said that voodoo was famous for Americans. Madame Cornhusk, the Obi lady.
Yeah, but the problem we have with that, and that's why we need to correct it. We trivialize what's their contribution, and we almost make it into caricatures, because that is how it is difficult for them to see the McNishes and the Tobis and the Huggins and the Mannings and all of those who clearly are not caricatures and who clearly have intellectual capacity, just needed opportunities, just as how those who left left Europe, Sicily, Poland, Ireland, in the depths of poverty, couldn't even read and write, and left America in search of opportunity. Just the story is no different. But it's different if you want to make it different. But I think we had a good talk on that.
Yes.
And I suspect that our conversation on the CCJ and the Court of Appeal is going to take more than this session.
Yes.
Now, the difficulty was I wanted to do this time. I want to hopefully we'll see what will happen next week. I really want to call the People's Forum. And one of the things I want to ask you, whether you're on Facebook, whether you are on YouTube, or whether you are following us on 102 FM, which we hope you're doing, because actually a lady from Atlanta called on another station and said she encourages people to come and listen to it. So whatever your media that you're using, I want to start by asking you, do you believe, yes or no, yes, that we should stay with the Privy Council? And as you say yes, we should stay with the Privy Council. No, we should go to the CCG. I want you to start giving your point of view and not only say yes or no, but give maybe any reason that you have that you are not convinced that they're independent, you don't think they're ready. Whatever your reason is, we are willing to hear it. You can call, that's even better. But if you want to do it that way, we would appreciate it. Because I think we want to, at least today, because I know we cannot cover everything. We cannot cover everything. I just want to do a little bit, and please call it, David. You are the control man here. I want people to call in, and all of this is, at least when you make a decision, let it be made with, knowledge. Say, okay, I made this decision because I've seen the arguments, and this is my decision, but not because, let it be your decision. And that goes to whatever I have to say too.
Yes.
You certainly don't have to agree with me. But what I was wanting to start with is I think that first I want to say when Courtney McNish spoke about the contracting parties, let me just clarify that for people. In 2001, CARICOM, all the contracting parties, which included Trinidad and Jamaica and Eastern Caribbean Islands, all of them, Bahamas and all of them, in 2001, they signed an agreement agreeing to the establishment of a Caribbean Court of Justice. So that's why you call them contracting parties. That doesn't mean, as we know, Jamaica and Trinidad has not done it, but they are contracting parties because they did sign the agreement to the establishment of a Caribbean Court of Justice. So that is why you see, as someone said, I think the current president of the Law Association, or I hope I'm not calling the wrong person, but someone did say that we have more Trinidad judges have sat on the CCJ than any other jurisdiction. And yet we are not a member of the CCJ. But we are a contracting party, and as a contracting party, we do qualify to be appointed as a judge. I'm not giving an opinion yea or nay on that. I'm just saying that is how we happen to have judges from Trinidad and Tobago sitting. We also have judges from Suriname. We also have judges from any Commonwealth country. So it could be somewhere in Europe that agrees with our civil laws, have the same civil laws, so they don't necessarily have to be even from the Caribbean, It's that wide. It's that wide in terms of the selection of judges. But when Courtney McNish spoke, one of the things that, of course, troubles me, of course, and he is right, that only 5 of the contracting parties are members of the CCG. I think the first one to make that bold step, if I may call it that. And please, you're calling and say, no, you don't agree. Yes, you do agree. I want you to feel free, to do that. I want your opinion on that. I'm just giving a little background. Is that the thing about it is that one of the first country in the 1970s, they just stopped, once they became independent, they just stopped sending their matters to the Privy Council. When the Caribbean Court of Justice was established in 2005, 2006, the doors were open. Then they started sending their matters, their appellate matters, appeals from their Court of Appeal to the Caribbean Court of Justice. So they were the first to do that. There are some countries that do require use of simple majority. Dominica apparently is one of those that just need a simple majority because they joined. St. Lucia joined this year, and they said it's because they made a mistake in their constitution. I can't say anything about that. All I know is that was the reason they gave. So they have joined the Caribbean Court of Justice. Belize joined many years ago, but what they did is they had a 5-year transitional period. So they said, okay, from the time we become independent, we will take 5 years. before we joined the CCG, and that is what we did. So for the first 5 years, the matters went to the Privy Council, and thereafter they went to the CCG. The other country that he mentioned, so that's Guyana, Belize is transitional. Barbados did it, I think they did it by referendum. I'm not sure. But for Trinidad and for the OECS countries, most of them, they need to do it by referendum. And unfortunately, the threshold that is required for persons to say yea or nay in 3 countries, Antigua, Grenada, and St. Vincent, the persons did not vote in the referendum in favor of having the CCG as their final court of appeal, although the current president of the Criminal Court of Justice is Adrian Saunders, who is from St. Vincent. Just coincidental. Jamaica, I think their own allowed by a civil majority, but it got so confusing reading the case that it became caught up with all kinds of constitutional arguments. So Jamaica, like Trinidad, we are still non-members of the CCG. We still have the Privy Council, our final court of appeal. So what do you think? Should we go that way? Because what are the major stumbling blocks? Because I know Mr. McNish told you, and understandably so, all the good arguments and valid arguments that we should become members of the CCG. One of that is our pride in our sovereignty. But as one politician, and I shan't call the name because I don't want, it's not about the political party. I read it first before I saw who it was. But the point they made, which was a valid point at the time, was that when we now got independent, we really couldn't see that we had a collection of jurisprudence, collection of Caribbean law, case law. We really hadn't had the hundreds and hundreds of years that England had. For us to suddenly overnight abandon the Caribbean Privy Council and establish our own final court of appeal. And so we needed that time, and we needed the time for us to do that. Today, I don't think there are very few of our judges who are not graduates of our law schools. And so there was a time when you needed the breathing space, definitely, to give us an opportunity to get the maturity or whatever you want to call it, to be able to give judgments that would have helped us to develop our own jurisprudence, even though, of course, people argue, well, how you could do that? We are an independent country. I mean, how we could be independent and we are a sovereign state, and you have these people in England decided our cases. Also, the expense, it is an expensive undertaking. Don't fool yourself.
Because Joycelyn Day, I was saying, not everyone can afford to go to the Privy Council. I say yes to the CCJ for the benefit of all.
Right. So that is and let me tell you, Joycelyn, don't underestimate that, Don't underestimate that. I'll say 2 things. When you had the pandemic, what I don't know if it still continues, it happened in my case, and I was glad for that, to be honest. Because of the pandemic, what the Privy Council was doing was hearing matters virtually. You can go to the Judicial Committee of the Privy Council, their judgments, and you can press, and you can actually not only see the judgment, but actually press and actually look at the hearing, even if the hearing was 5-6 years ago. You can do that with the Judicial Committee. So in my case, as happened in many, many, many cases where you're not the government and therefore your pocket's not that deep, they allowed you to hear your matter virtually. But still, even if they allowed your attorney, your counsel, to argue the matter from Trinidad or whatever Caribbean island, you still had to have an English solicitor firm representing you doing all the legwork and having to pay them in pounds sterling. So even though you got some ease up there, there's still, and then if you have to send your attorney, your advocate to England, you have to pay his airfare, you have to pay for his stay in England, and if he's a senior counsel, he would have to pay for junior counsel because that's how it goes, and you'd have to pay for the lawyers, the British law firm, and you have to pay them in pounds sterling, right? So however you cut it, even if you have these virtual hearings, which I don't know if they have suspended them or if they still allow what they call it's not all virtual. You can do it part virtual, part in person. But it is an expensive undertaking, and that's what matters where the government is involved in. That is why you can't fight them. You cannot fight them. Their pockets deep. So they will frustrate you. Not only the government, but any wealthy person who knows that they owe you, but don't want to frustrate you and want you to, they call it attrition, get fed up because it's taking so long because they're going for this application and that application and this application, and meanwhile you are getting no money and you having to pay your lawyer, and it's going on and on until they break you, because once they appeal, even if you win, once they appeal, you have to defend. Because if you don't defend, it means that they would have gotten judgment against you. So they force you to defend. And then even if you win again, which is what happened to me, they will appeal again. And when they appeal again, they force you to defend. Because if you don't defend, they will get judgment against you in the fault of a defense. And that's what I went through for 20 years. Much less if I went through that. People will say, but what you complaining about, you are in a better position. So much less for other people who are not able to have the wherewithal, the stamina, the ability to stand up against the deep pockets. And the government pockets are the deepest pockets. So sometimes when a person lets go a matter, unless there's a lawyer who's willing to do the matter, what they call pro bono or whatever, sometimes you have to give up because you don't have the wherewithal. They will break you. When they finish with you, you sell all the land, you sell all this in order to pay lawyers' fees. Because they don't have, you didn't see how much they spend on lawyers? And it's bring all kind of cases. You wonder why they bring in some of those cases. You really wonder why they bring in some of them cases, but I will not get myself in trouble over that. But all I will say is it's a really a hard thing to have your matter go to the Privy Council for many people who have a good case but simply do not have the money to, and they will frustrate you with time and money until you finally drop the case. So that is one good argument for having a Caribbean Court of Justice. You go down the road, it's in Vincent Street or wherever the Caribbean Court of Justice is, your lawyers are local, and the costs are probably cut in half. The other thing that you can use it both ways, it goes for or against you depending. Sometimes they say the fact that they are removed from your social economic situation and the political environment does not allow them to have the sensitivity to the issues brought before the court. But sometimes that can be a good thing because it means that whatever their judgment is, whether you agree with their value system or not, because that's what you're really doing. It's their value system. You'll not be able to say it's because they're friendly with this one or they're friendly with that. Well, you might say it still, but it will have less weight. So those are the main reasons: the cost, the issue of sovereignty, and the question of a lack of your really having a understanding of the social, economic, and political realities of the country. And I'm waiting on people to join and give their opinion as to whether we should have a Privy Council or we should go with the CCJ. What's your views on that, David?
Well, Trinidad has become so corrupted in all different spheres. I know a lot of people, well, like you said, once they can afford to go to the Privy Council, they will go to the Privy Council based on maybe the biases that they might be, thinking about or probably realizing, with the local judges and stuff. Because a lot of people will say that nah, them judges in Trinidad, they are some friend, or they know someone, or it's easy to get through to them, maybe through corrupt practices and whatever. So what I would like to know is how independent these judges are when it comes to dealing with public matters. How are they are they in a position where corruption can seep through and create a different sort of value in justice?
But that's why the CCJ is set up as it is, to avoid exactly that kind of political interference.
Yeah.
And
but it might not only be political. There are people in the private sector and thing who can try those kind of what should I say, advances if they need their matter to be heard and in their favor.
Well, I think that is part of the what should I say, the risk involved in litigation. But it still does not take away from the arguments that the CCJ may have sufficient independence and capacity and ability to hear matters in the same way that the Privy Council does. So we're not talking about the local courts. If that person may be referring to the High Court or Court of Appeal, there's still the CCJ. And if there are enough checks and balances and protection, that perhaps people can take comfort that the CCJ has given us enough of those protections. I think one issue that I would want to bring up because of time constraints that we have, and talking about the CCJ and the Court of Appeal, and I had a whole set of matters that I was going to raise, but I think one of them that really stands out in terms of whether the CCJ was our final Court of Appeal as opposed to the Privy Council is the death penalty cases.
Before you continue, just a nice guy. Just a nice guy. That's how it is. Just a nice guy is saying CCJ all the way for the local man. But the question is, how do we know when the judges are corrupt or not? Same thing like I've been asking you there. So I'm just reading the comments that are coming up. Another one.
I understand what he's saying.
Yeah, Mars versus Venus. Our country's population is too small to have high levels of integrity. After 3 generations of families, you have family and friends all over the place. So you see how I think that's the main concern, because the first time I heard about the CCJ, I said, okay, that sounds fantastic. But, the level of corruption is so high. It's difficult to understand, when you think about these guys in England, nobody knows them. They're not easily bought. You don't have a friend to say, well, I will pass this note to this friend and have my case aired and adjudicated on without bias. So I know for some people, they will prefer the Privy Council where that is concerned, because I think just like Mars versus Venus and just a nice guy saying, and I too am saying the same thing, is how do you get away from and be asserted that that kind of thing, behavioral patterns won't happen, because with straight faces these things can happen. You never know what's happening behind the curtains or under the table. You never could know what's happening. And I think that goes for the level of thinking about the CCJ in the Caribbean. I wouldn't say Trinidad alone.
And I understand. Don't think. Listen, when I'm trying to be careful in not giving my own. I gave you my perspective about my matter because of the peculiar circumstances.
Mm-hmm.
But don't for 1 minute think that I don't understand what both Mars and Venus and just a nice guys is.
Yeah.
Right. And more of these, I want more comments would be appreciated.
Yeah.
I understand what they're saying. And I'm going to give them one example. And that will be the one example, because what time is it now?
It's 26 past 5.
Right. Okay, so I will only be able to give this one example. And it will probably make both of them feel, you see, well, be right. Okay. So I chose cases where the state was involved. And the reason why I chose cases where the state was involved, because it affects all of us. All right? Now, I don't want to get into too much legalese and then lose people with too much legal language. But what I want to say is the death penalty cases are the best example of the difference between the CCJ and the Privy Council. Why do I say that? Starting with Pratt and Morgan in Jamaican case, where and I think if that case, after reading the later cases in Trinidad now, I wonder if we did the right thing, but I'll come to that. Starting with Pratt and Morgan in 1993 in Jamaica, where this man was held for to be executed past, I think, about 10 years or whatever. He argued a constitutional argument that to execute him after how many, I don't know how many years he was there, but it was many, many years, would be cruel, harsh and cruel punishment, which was an infringement of his constitutional rights as set out in their constitution, similar to us. We have it in our section for the human rights. And the Pratt and Morgan decision of the Privy Council determined anyone who is in death row for 5 years or more, their sentences should be automatically commuted to life in prison. And I know our former Chief Justice, Michael Labusy, may God rest his soul, wrote an article. He was beside himself because he said, we have legislation in our books, Offense Against the Persons Act, Section 4, which says that every person convicted of murder shall suffer death. You are having some British law lords telling you that your law, although 1925 it was passed, so that's a lot to do with the savings provisions. But anyhow, I'll get to that. But his point was that you're having some British law lords who have decided they're anti the death penalty, don't think anybody should be put to death and are against it and all of that, imposing their value system on former colonies, independent nations, and in effect taking our legislation, our statute law, and saying that our statute law has to follow a decision of some law lords in England. He wrote an article on it, and he was really incensed about that. And what happened as a result of that, all the Caribbean islands, because we all go to the Privy Council at that time, I don't think any of us at that point in time, maybe except Guyana, were all still going to the Privy Council, decided to commute everybody who was on death row, their sentences to life in prison, because they felt that if they had gone and taken their case to the Privy Council would have come back with the same decision, 5 years or more, you cannot execute. That's a cruel and unusual punishment, and it is against your human rights and unconstitutional. So that was the beginning of how the Privy Council determined that our laws could not be invoked, even because they said that it was unusual. No, I am not giving my opinion on it. I'm just giving you the fact that how you're seeing how the Privy Council has a sovereign state, how much power it has. And now you really see it now that we now have the CCJ, and you have countries like Barbados who have gone to the CCJ. They didn't originally, but they are now have the CCJ as their appellate court, just as St. Lucia has, just as Guyana has, as I mentioned. And the famous case was a case by Moday, that came out of Barbados. And I just want to read to you what Sir Byron, Justice Byron, who was at that time the president of the Caribbean Court of Justice. And he said that the provisions in our Constitution which saved laws that existed before we became independent, they cannot be implemented willy-nilly like that. But this is what he has to say. This is telling how strong he felt about it. In that case, which was led to a Barbados case, he did not impose the death sentence. He did not impose the death sentence, even though the laws otherwise would have said previously, if they were with the Privy Council, he would have had to. But because they were before the CCJ took a different point. And this is what he said. The CCJ heard an appellate appeal from Barbados. And said Byron did say the leading judgment. I don't want to get to the point. They held, I don't want to get too much into the law. I want to get to the point that he says the second question is whether the mandatory death penalty in Section 2 of the Act, that is their Act, should be in Barbados Act should be imposed. And he says, and he was so strong in his objection to it, he said that I was wanting to use his word because he was really beyond himself. He said, the first issue with President Byron addressed was whether Section 11 of the Barbadian Constitution, which declared the fundamental rights and freedoms of the individual, and the start of Part 3 of the Constitution was a preamble. I want to get the part where he talked about how we are free people, where he was so angry. He said the General Saving Clause is an unacceptable. This is what he's talking about, the Barbados Constitution and this thing about inherited laws. He said the General Saving Clause is an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. The idea that even where a provision is inconsistent with a fundamental right, a court is prevented from declaring the truth of that inconsistency just because the laws form part of the inherited laws from the colonial regime must be condemned. So I told you, I'm giving you an example without going into the law to tell you that if we were part in Trinidad and Tobago, we had a series of cases. And those series of cases, Rudal said that you could not, the death penalty clause in our act was not a fixed penalty, it was a maximum, meaning that judges could have the right to impose something more than the death penalty. They could put life imprisonment because there are different circumstances and the judges should be allowed to do that. So Rudal in the Privy Council said, yes, we read the provision and we are still saying that we should have the right that to give the judges the right to have a maximum rather than a fixed penalty. Well, the Privy Councillors were in a tizzy. They couldn't believe that. So in 2-2s, they had a 9-member panel set up and they heard a case called Rudal. And in Rudal case overturned that case. Rudal's case was overturned by Matthews. Sorry, Rudal's case it said that you could go up to. You don't have to impose the death penalty. You could go up to the death penalty. But after Rudal was heard, the Privy Council went into tizzy, I have to say, and they heard a case called Matthew just soon after another murder case with the same provision that the penalty for murder shall be death. And they said the decision in Rural was wrong, that there is no such thing as up to, it's no such thing as maximum, it's a fixed penalty. And even if it goes against your constitutional rights, even if it infringes your constitutional rights of protection by the law, all the provisions, because it was passed before 1962, before you became an independent country, because it was passed before 1962, it was passed in 1925, and because it was passed then, that is our law. And that law means, according to the Privy Council in Matthews, that judges had no right to impose anything else but the death penalty. And by the way, when England abolished the death penalty, the next year they had a rise in murders, by the way. But the point is, it's not whether you agree with them or you don't agree with them. You are having the Privy Councillors in England telling you how to interpret your law. And I read you something from President Byron, as he was then, from the Caribbean Court of Justice, and talking about how you talking about independent nations imposing your rules, and us, we don't care what your arguments are. We are not going to follow that. And in Nunez case, which was a case that came from Barbados and went to the CCJ, they did not follow the Privy Council, and they commuted the gentleman's sentence from murder to life in prison. In the Privy Council, to which we still belong, after Rural said you could go, could be life imprisonment, or you could be saying you have a discretion, Matthews turned around and said, no way. And you know what they had to do? What they had to do, there were a number of persons sitting down in waiting execution, over 50 people sitting down waiting waiting for the death penalty to be executed. Some of them 5 years, some less than 5 years, some of them 10 years. One of them was a man called Boudram. All of them, the Privy Council had to say, well, given the decision that we came to, that was come to in the Rural case, there was an expectation by all those people sitting in the death penalty row that they could get their sentences reduced to life imprisonment. All of them, regardless whether they met the 5 years or not, their sentences, all of them, and I think it was about 50 of them, all of them, whether they met the 5 years or not, all of them had their sentences turned from death penalty to life imprisonment. But do you see, I've given you a very clear example for those who are listening. If you want to argue what's the difference between having the CCJ and having the Privy Council, the death penalty cases are an example. I am not an advocate one way or the other. I haven't studied the death penalty. I don't know if putting people to death will just change it. I don't know if Dolce was the last, and his group in 1999 were the last other persons who were hung in Trinidad. They've done so many studies that it doesn't really make a difference, or makes minimal difference. They've done studies all over the world, about whether death penalty. So I am not here to argue for or against it, because I know maybe people listening to me really say, what's she arguing that for? They should put them to death. I am not arguing that point. This is my point. I am trying to say that if you want a very clear example of the difference between the Privy Council and the CCJ, is the death penalty cases. Because if the CCJ was your final court of appeal, as it is for Barbados, as it is for Guyana, as it is for Dominica, as it is for St. Lucia, as it is for Belize, if that was your final court of appeal today, it would not be an automatic position, because they reinforced it with the case in Chandler case. If they had any doubt, they said again in Chandler case, which was more recent, a very recent case, and confirmed that when the 1925 Act, the pre-1962 Act, said that the penalty for murder shall be death, it means exactly that. And even if it offends your protection against all of Section 4 protections in your Constitution, the supreme law of your country, even if that act offends all of those rights, all of human rights, protection of freedom of expression, freedom of protection from the law, all of those rights, even if it does all of those things, it matters not, because it existed before 1962, and those provisions will not affect any act that was passed before 1962 that has not been repealed and changed. And we have not changed the law in our parliament as yet. So that is the position in Trinidad and Tobago. So I use that example, which I think is a very clear-cut example of the difference between the Privy Council and the Criminal Court of Justice in relation to the issue of your sovereignty, in the issue of you having the right to decide, for your judges to decide, that's the CCJ, to decide, yes, he deserves the death penalty. No, he deserves life imprisonment. And you know what happened because of that case? Because of that case, one of the gentlemen who was in prison for about 11 years, Mr. Boudram, he had some smart lawyers, or he himself must be smart. He went to the High Court under Section 14 and says, under the, I think under the Constitution, Section 14, once you are in prison for life or any sentence that involves anything except death, you are entitled to go to the High Court and argue for a lesser sentence. So he went to the High Court to argue to have his life imprisonment sentence reduced because of the decision in Matthews and Rudall. I hope I have been clear. Have I been clear on the matter?
Yes. Yes. Justin the Arsing is saying, very articulate, Miss Karen, but I get a real headache. Mars versus Venus is saying, with power comes responsibility. Are our administrators acting in a responsible manner in their duty to the country? That is the question here. Mars and Venus is put in. Are our administrators acting in a responsible manner in their duty to the country?
So I am going to give him a case that will probably answer that. And I really didn't want to come to it, but since he wants to know that, I just have to repeat it. I don't know if you know that there was a case where the DPP brought against the cabinet of, I think that's the cabinet of Trinidad. It was the cabinet, the DPP basis, Chris Barron, anyway, and two others. So the point of the matter was that these men were facing the criminal proceedings for murder. And the criminal proceedings were going along by the DPP, because under Section 90 of our Constitution, it is the DPP who institutes, undertakes, discontinues criminal proceedings in respect of any offense against the law in Trinidad and Tobago. Right? So they were alleged that they had committed murder. So the matter was going on. And after they had a major witness, and this witness swore that these three men did do it because he knew the man and la-di-di-da. So he was the crown. This was the DPP's witness against these men. Just before the matter was had started, and they were just going over the evidence with this gentleman, he say, well, when I go in court, I will say the same thing, but it's not really the truth. The reason why I said what I told you all is because they had had too much fighting and things. I wanted to bring peace to the place, and these guys were involved in too much criminal activity. So I figured if I get them locked up, the place will get a little peace and quiet. But I wouldn't say the same thing I tell you all, but the truth is I really didn't see anything. So what did they do? They went to the civil courts and asked the civil courts to say that the criminal proceedings must be stopped, and they quashed the judicial reviews. They reviewed the decision of the DPP, said that the criminal proceedings had to be stopped, and any indictment against the three men was quashed. Well, I'm only going to read to you what the Privy Council had to say about the actions of the Court of Appeal, because this went to the Court of Appeal. The DPP went to the Court of Appeal because he wanted to say, I am in charge of criminal proceedings. We have a Criminal Proceedings Act. There are all checks and balances built into the legislation. There are all the disclosure to the defendant's lawyers were made. There was nothing that I had all the ability as the DPP to be able to manage the outcome of the matter. There's a judge, there's a jury, there's a legislation, and there had been full disclosure. Now the matter went all the way to the Privy Council because he challenged the right of the civil courts to interfere in a matter in which he, as DPP, was bringing proceedings, and not only interfere and say his actions were unreasonable and irrational, but also quash his decision. In other words, overtaking the DPP. This is what the Privy Council had to say. I'm just only reading it, it's 3 paragraphs. This appeal arises out of an unfortunate sequence of events, commencing with the seeking and granting of leave to apply for judicial review on a without notice basis, meaning they didn't even tell the DPP. The DPP was not even notified, so they had a hearing without the DPP being present. The board agrees with the decision of the minority. That was Justice Barrow did not agree with his majority that they didn't do anything wrong, that they had the right to do what they did. The board agrees with the decision of the minority that leave to apply for judicial review should not have been sought or granted at all, let alone in the absence of the DPP. The criminal trial was due to restart within days and provided an adequate and effective alternative remedy for the responders. It is important for the courts to guard against the danger of unjustified collateral attacks on prosecutorial decisions, as the authorities confirm occasions when it is appropriate to judicially review a prosecutorial decision, whether to continue to prosecute, are extremely rare. In the present case, there was unwarranted interference by a civil court of concurrent, meaning equal, jurisdiction with ongoing proceedings in a criminal court. For these reasons, the appeal will be allowed. It will be for the DPP to decide what, if any, next steps are appropriate. That is what the Privy Council did. You gone and allowed people to make judicial against the DPP and squash a decision, and the Privy Council told them, but you have no right to do that. That is not, you have no right. So that was a recent decision. It came out on the 25th of April this year. So, I think, have I been clear on that? I didn't go into all the nuts and bolts. Have you had a headache, Mr. Alson?
You know, that sort of comes right back to why most people would prefer the Privy Council than the CCJ. You know, in a nutshell, it sounds as though you can have things done in some other way via the local judiciary and by extension the CCJ, and it will be totally different to the Privy Council. So there are some people who would say, no, let's stay with the Privy Council because I have a problem with that because I think we should have our own distinguished judges be the final appellate court. But sometimes when you see what's happening around and you hear what's happening around and where people can fund their way through circumstances that might be unbelievable because it will cost a lot of money, and they will show you that they have that kind of money to buy, their way in and out. So I guess that's the toss up with the Privy Council and the CCJ where I am concerned. So I am learning this. I'm not good at law, so I'm learning a lot. I mean, based on what Mr. McNish said, and I tie it in with what you are saying now. It will have you like one foot on this side of the white line and the other foot on the other side of the white line, because it's probably based on the quality of the case, or what the matter is really about, whether you should stay at home with the CCJ or go beyond and have the Privy Council decide. It sounds so
Yeah,
to me.
what it does is that when you get decisions from the Privy Council that actually, I mean, in no uncertain term, criticizes the civil court for interfering with the criminal proceedings brought by the DPP
Mhm.
in no uncertain terms, and said even I have the judgment here, but he says even the argument about it being unreasonable, his behavior was unreasonable and irrational. The Privy Council fraud that he said that I mean, to be clear, there's so no merit in that argument whatsoever. I think it was made by the High Court judge.
Yeah.
But when it came to the Court of Appeal upheld the High Court judge. And were it not for the Privy Council and the DPP feeling strongly about it, it would be a situation now. I don't know what he's going to do, because the civil court have quashed his sentence. So what is he going to do now? But what they have sent a warning signal, right? What I think this case has sent, and I think that's why the DPP went forward with it, is because it's sending a message to the civil jurisdiction of the court that when matters are before the criminal jurisdiction, don't interfere. And it was wrong of them. This is what the court is saying, the Privy Council is saying. It was very wrong of them to entertain an application to review the decision of the DPP when the DPP has all the built-in checks and balances to ensure that the Constitution gives him the power, number one. And then apart from that, the criminal proceedings legislation, the fact that there's a jury trial, the fact that there's a judge who sums up a case. Remember, the DPP is the one prosecuting, but he's not the judge, he's not the jury.
Yes.
And then there's the criminal proceedings legislation that guides them. They have all those checks and balances built into the criminal law system that has come and to hear the application for judicial review in the absence of the DPP, without him given an opportunity to be heard and to defend his position. They took great umbrage to that. So I don't know what he will do about that matter, because, I guess I can't speak for the DPP, but what it has sent is a signal to the civil courts that when the criminal courts, unless you have this very rare, and the dissenting judge was Justice Barrow, he said that's so rare, it must be as rare as a blue moon, I think. He didn't say that, I'm saying that. So, in other words, the opportunity for the civil court to interfere with the jurisdiction of the criminal court are almost non-existent. And this was to me a telegraphing to the civil court that the DPP has criminal jurisdiction, and there are enough checks and balances built into the criminal jurisdiction, as I said, that there is no need for the civil courts to intervene and effectively without his presence, the president of the DPP effectively say that to continue with the proceedings is unreasonable, it's irrational, and etc., etc. So
Joycelyn is saying very clear. Thank you very much. I understand. Joycelyn Dial Singh, she's continuing saying, Very clear. Thank you very much. I understand how the Privy Council could be a crucial step in this case. And in conclusion, she said, I will have to rethink my position favoring the CCJ as the final court of appeal. That's my whole take on the thing. You see how she summed it up there? It's the same way I feel about the CCJ as compared to the Privy Council.
And I'll give you one more example. So just so you will really have to think.
Yeah.
All of us will remember it. It happened just recently.
Mm-hmm.
Under the Municipal Corporation Act, councillors and aldermen have a period of service of 3 years. Now, they have a local government. It's a long name of the legislation. But basically, what the government did, they passed 2 sections in that act, proclaimed it, so gave it life, allowed it to be implemented, right? And those sections would allow aldermen and incumbent, those who were serving at the time, still serving at the time, for them to serve another year. Instead of 3 years, to serve for 4 years. Well, let me tell you, that matter went to the Privy Council. And let me tell you, Ravi Balgobin brought the case. And let me tell you, they tore. The Court of Appeal, I think, agreed. They upheld the Court of Appeal's decision. So we have to say that the Court of Appeal were in agreement with what the Privy Council said. And this is what they had to say. This is what the Privy Council had to say. So the Court of Appeal did agree, but this is what they had to say. I mean, oh God. I mean, they really gave the government some good licks here. And this case was heard last year in March. That was the case about these councillors and incumbents, whether it applied to new ones, the future ones, or the ones that are serving now, whether it could extend to another year. And I'm just going to read how harsh they were, because someone said it's not only the decision, it's what they say is also important. So paragraph 31, this is what they said. I'm just going to read it out, and that will be the end of my discussion today. They said the central characteristic of a representative democracy, whether at a national or local level, is that the representatives are chosen by popular vote. In a modern democracy such as Trinidad and Tobago, all individuals have the right to participate in the popular vote, subject only to specified conditions. In the case of municipal corporations, the popular vote is direct for the councillors and indirect by means of party lists from aldermen. It is also an essential element of any democratic form of government, whether at a national or a local level, that the electorate choose their representatives for a limited period. The right to vote out representatives is as important as the right to vote in representatives. At the end of the period for which they were elected, the electorate has the right to decide whether they wish the incumbent representatives to remain in office, assuming they stand for re-election. 32. The rights conferred by a democratic system of government are not only individual rights enjoyed by each person entitled to vote. It is also the right of all members of the relevant community to be governed by representatives chosen democratically, whether or not individually they are entitled to vote or have exercised that right. 33, and I'm going to end with 34. A democratic society will necessarily engage other rights, freedom of expression and association, for example. But the election of representatives for a fixed or maximum period is the foundation on which it is built. Finally, it is inimical means terrible, just in case. It is inimical to a representative democracy that the representatives are chosen by anyone other than the electorate. It is not for Parliament, that when they passed Section 22 and 23. It is not for Parliament, still less the government to choose the representatives. But if the amendment to Section 11 and 12, 11 and 12 are construed to apply to the incumbent councillors and aldermen, the effect will be that they have been chosen as representatives for an additional year, not by the electorate, but by the government, which brought the amendments into force while those councillors and aldermen were still in office. So it's the election 11 and 12. You hear what the Privy Council had to say about what the government did?
Mm-hmm,
right?
Mm-hmm.
So I hope all those who heard me That is not what I said. It's what the Privy Council has to say.
Yes. Before
So
before we
have to
go, Mars versus Venus is saying, was there ever any decision on having more magistrates and attorneys disciplined for unnecessary delays to uphold swift justice with civil cases? Justice delayed by attorneys should be addressed.
Well, that's a whole long discussion. And I actually, when I was teaching at the law school, faculty of law in Barbados, I actually compiled a whole set of cases because, it is really unfair that your matter, which you are, your lawyer is your agent acting on your behalf, right? I mean, the cost and the agony of delay upon delay, shouldn't the other side be made to pay something for delaying your matter? Shouldn't they be the ones that should have to say, the court should say, you have given no good reason why you are not ready today. Because they do have the power to make an order against the lawyer's person, but as far as I'm aware, I say that carefully, as far as I'm aware, it is not imposed insufficient a number of times. Because I personally felt that the amount of times that the other side would come with all kind of spurious excuses upon spurious excuses. And I'm saying to myself, who is the one that's suffering? I am the one that's suffering. I am the one that my matter. I don't want to make it about me, but anybody. So I just using me as an example so that I could relate to what you're asking me. I said the lawyers should be made to pay for that. Let them take it out of their pockets because there is provision for that in our laws, our code, our rules, our civil procedure rules, that they can make an order of cost against him personally. And I find the judges need to use that more. And you'll see how then those lawyers who don't take your matter and are not ready, or for whatever reason they're not ready, as can happen in other cases, not mine, but other cases that can happen, and they pay nothing. And you, the client, have to stop and waste your time. They're coming to court, and they're the lawyers, the other side, pay nothing for that. It's you are the one paying, because at the end of the day, guess somebody's going to have to pay for that application. And you better believe it will be a price for that.
Yes.
So I agree with you, the gentleman.
Yes. Mars versus Venus.
Yeah, Mars versus Venus. I don't know what you mean by that, because I don't know where you see that from. But anyway, yeah. I agree with you, and it is time that the court make the lawyers pay when the matters are adjourned, and because justice delayed is justice denied. You are very right. I agree with you on that. But I'm making that as a general statement because, of course, there are good reasons why matters are delayed and so on. But as a general principle, I think you have a good point.
Thank you so very much, Karen. We're way out of time now.
Yeah, okay. I can't see you, see, because I put on the wrong glasses.
Yes, it's been very informative, and I know a lot of people lapped up the information. And
they did, I hate you.
Yes. Even myself, I learned a lot today.
All right. Thank you very much for listening, and hopefully we can continue our discussion. And please, be part of the discussion. I would really appreciate it.
Yes.
We love to hear from you.
Yes.
Oh, excellent program. Thank you very much. Thank you very much.
Yes.
Okay. See you next week.
Okay.
Bye-bye.
Bye-bye. That's it for today's edition of Hard Talk with host Karen Nunez Tesheira. We dealt with the topic Caribbean Court of Justice versus the Privy Council. Karen will be back next Monday for another edition of Hard Talk right here at Power One.